Good afternoon, everyone. We're going to give people a couple more seconds to filter into the room, and then we're going to get started in just a few moments here. All right, we've evened out on participants entering, so good afternoon. Welcome to Understanding Maine's proposed Paid Family and Medical Leave Program Rules webinar. My name is Tawny Alvarez. I'm a partner in Verrill's Labor and Employment Group, and I am excited to be joined today by my colleague, Main Street Solutions Senior Government Relations Specialist, Peter Gore. Today, we're going to be discussing proposed rules and provide you all with a better understanding of what Maine's new proposed rules related to the paid family and medical leave program look like, how they interrelate with statutory obligations that all employers have, and what opportunities businesses have to voice their support or concerns regarding the proposed rules. A couple of quick notes before we get started. For those of you who aren't familiar with Verrill's webinar series, this will be recorded and it's going to be emailed out to all of you along with a copy of the slides in the coming days. Additionally, if you missed our original presentation on the paid family and medical leave program itself, as opposed to the rules interpreting it, please check out our website to find out more about the law itself. Also, this webinar has been approved for one CLE and one SHRM credit. Please note that the CLE credit is a PRAC Pro credit. If you are an attorney, we'll be submitting your name to the Maine Bar for CLE credit, and we'll also be emailing a certificate of records for your records, as well as a SHRM certificate if you're seeking SHRM credit. And if anyone has any questions during the presentation itself, please enter them into the Q&A box, and we'll do our best to answer them in real time. With that, thank you all so much for being here, and let's get started. So why are we here? Peter and I have talked about this a bunch, but we want to make sure that we kind of foundationally discuss what we're doing. So right now, the rules that we're about to discuss are still proposed. They could change, but they can only change if we speak up. If we speak up and say, yes, we really like this part of the rules, or no, we really don't like this part of the rules because it's going to be problematic. The state, the department itself has given two opportunities to have those dialogues. One is at a public hearing that's scheduled for Monday, June 10th at 9 a.m. It's in Augusta, and it's at 45 Commerce Drive. That's an in-person meeting. The other opportunity is to provide written comment. You can do that through July 8th, 2024, and you can provide it in a written format, and you can address it to the Paid Family Medical Leave Program at 50 State House Station in Augusta. You can also go onto the Maine Department of Labor website to the Paid Family Medical Leave Act subpage, and there is a section in there in which you can identify what elements of the program you want to provide comment on, and then you can submit your comment. We also want to make sure that we're clear from a timeline perspective. So even though we're talking about proposed rules right now, everyone should recall that under the statute itself, payroll contributions for this program begin January 1st, 2025. And benefits that individuals would be eligible to receive, they begin May 1st of 2026. And one of the questions that we've been getting a lot is, does this apply to me? Peter, is this a law that only applies to employers with 15 or more employees, or large employers, or who does this law apply to?
Thanks, Tony, and good afternoon, everybody. So to be clear, we had almost 200 folks sign up for this. And I'm sure some of you were asking yourselves, well, does this law apply to me? Yes, as I looked at the RSVP list, this law applies to everybody who is here today because it applies to every employer. And also, if you choose the self-employed or independent contractor in the state, whether you're a for-profit or a nonprofit. There is the narrowest of exceptions for federal employees, but beyond that, it applies to every business in Maine, regardless of size. It applies to all full-time, part-time, and seasonal workers. And so these rules are very important, not only for how it's going to impact your cost of doing business, but how you will manage your business and absences. So yes, everybody's in.
And we know now from the rules, at least the proposed rules themselves, are looking to exempt only 3 classes of employees. So while all employers may be covered, 3 groups of employees may be excluded from coverage. Those would be your incarcerated workforce. It would be your work study program individuals who are working through state of Maine. And then also it's going to exclude those who are covered under the Railroad Labor Act. So let's jump to the next slide and really start talking about what today's presentation is going to look like. Peter and I have spent a lot of time with both the law itself and these proposed rules, and we've tried to organize it in such a way where we didn't just take all of the things that we find concerning and throw them at everyone, but instead we wanted to set it up in a way where we had top of mind concerns for everyone and then spend some time sprinkling in other concerns that people should still have in their pocket, understand how it's going to affect their workforce, but maybe not at top of mind. So let's jump in with those top of mind concerns. So the first one is private plans. For the last 9 months, Peter and I have been getting a lot of phone calls concerning what do private plans look like? What does it have to include? Can it be self-funded? What would it look like? Well, the good news is that the proposed rules do provide us with some guidance as to what a private plan could look like in this program. The bad news is, and Peter's going to touch on that a little bit, is there's still some problems. So I'm going to talk about what the rule itself provides, and then I'm going to let Peter jump in and talk about why this may not be sufficient and some of the concerns we see already. So under the proposed rules, we could have either fully insured private plans or self-insured plans. And this would be an employer substitution, so you wouldn't be using the state program itself. Instead, you could go to market and you could purchase a fully insured plan, which is going to require that it be a program that has gone through Maine Insurance Code and meets Maine Insurance Code provisions, or it can be a self-insured plan that the employer themselves creates and insures themselves. Those ones are going to require that a bond be provided, furnished to the department in an unknown amount, so that's unclear, as well as a surety company that's authorized to transact business in Maine. The timing of those private plans, you can apply to use a private plan after January 1st of 2026. So recall, these rules take effect, or you can start taking leave under the rules on May 1st of 2026, but you can't make an application until January 1st, 2026, and that plan cannot become effective prior to May 1st of 2026. But when you dig deeper into the rules, note that you have to make quarterly payments. So you would have to make a quarterly payment for the second quarter of 2026. So that means that you'd be paying through June 30th of 2026 based off of the proposed rules. There is an application fee that's noted. The amount of that application is not specific. And additionally, if you apply for a substitution plan or a private plan, whether fully insured or self-insured, you have to use it for 3 years from the date that you're submitting it or date of cancellation of a previous plan. So they're in 3-year increments. Peter, concerns as to what we're seeing as it relates to these proposed rules?
Yeah, maybe the easiest thing for me to do is translate this into reality. One of the most frequently asked questions I get is, our company currently provides a plan that is at least equal or as generous to, or more generous than the plan that the state is putting forth. Can my plan qualify? Can our current company plan qualify as a substantially equivalent plan? And oh yeah, by the way, we don't charge our employees any premium for that kind of coverage. The answer is not until until the beginning of the second quarter of 2026 will you know the answer to that question under these rules. And the reason is because the state wants to collect premium dollars for you to capitalize the fund. It was estimated that at the time the law was passed, there would be approximately $360 million necessary to make the fund operational. Under the proposed rules, all employers, even if you have a plan that you think is substantially equivalent, or you'd like to purchase a plan on the open market, those plans won't be available for you to at least look at until 1/1/26 under these rules. And then you would have to wait until the first day of the following quarter in order to actually purchase it. That's a significant cost, particularly if your company believes you will never use the state plan. It's probably been the most controversial part of these rules. And there are a number of things, if you are concerned about, that you can ask for. First of all, you can ask for a change in the timeline for the approval of substantially equivalent plans to 30 days after these rules have been finally promulgated. You could ask for businesses to certify to the state that you intend to purchase a plan, or you believe your plan is substantially equivalent, and then be prepared to pay penalties and additional taxes if your plan is found not to be substantially equivalent. So I would urge you to look hard at what you do provide now. But to be clear, that the state should not be accepting applications prior to November, or should be allows them employers to start opening up the application process in November of this year. So by the time the next quarter comes around in January, your plan has been deemed substantially equivalent, or you believe a plan would be available on the open market through another carrier to cover you, and you would not have to pay into the state plan.
Now, one of
Tawny?
one of the other aspects that we're hearing a lot of is what's substantially equivalent plan. What does that mean that I have to include? Now, the proposed rules do include provision within section 13BD. So 13BD is the definition or determination of substantially equivalent, what the department's going to look at. It is interesting because they are clear that it does not need to be identical, but then later in it, it notes that the plan must provide the same or greater aggregate monetary benefit to employees. So while it doesn't have to be identical, it has to be able to provide the same or more benefits to employees. One of the interesting things that's missing, though, thankfully, and I hope this is because the department heard so many of our concerns, is that it does not currently, under the proposed rules, appear to show that you need to cover affinity relationships. We're going to talk some more about affinity relationships later, but if you are considering a plan that's substantially equivalent, right now, the language does not indicate that you have to include affinity relationships as one of the reasons that an employee would be permitted to take leave.
Let me just say one other thing about this declaration of intent. There's been a lot of discussion about that, and early on, the department had indicated that they would be open to the idea of an employer saying, "Look, I'm declaring that I'm going to purchase a plan, or I believe my plan is equal to or better than the state plan." And then it may not be exact. For instance, you as an employer may provide 8 weeks of benefits, but at 100% of an employee's wages versus 90% if you earn less than 50% of the state's average weekly wage, or only 66% if you earn more than the state's average weekly wage. So you may believe your plan is better, even though it doesn't align perfectly. But so you would file that declaration of intent, and then you would not have to pay the tax, the 1% tax for your business and your employees. And if your plan was not found to be acceptable, then you would have to then pay back the taxes on both ends of the spectrum for the employee, or for yourself as an employer, and also for employees. But the department has backed away from that, and they're not allowing this in these rules. And so they are making sure that they are locking all businesses into paying the tax for at least 16 to 20 months in order to come up with the necessary capitalization.
Let's jump to talk a little bit more about affinity relationships. So you may recall, if you've joined us previously, that within the terms of the statute itself provides the reasons in which an individual can permissibly take leave. And one of those reasons is to care for a person that your employee has an affinity relationship with who has a serious medical condition, right? Under the proposed rule, affinity relationship is defined as a significant personal bond between a covered individual, which would be your employee, as long as they meet the other definition requirements, and another individual that is or is like, which is interesting, is or is like a family relationship, regardless of biological or legal relationship. And it's limited to one designated individual per benefit year. Now, Peter, any concerns here more generally? I mean, it seems like a pretty big relationship and very little language about how we're going to determine an affinity relationship.
I mean, I think you just said it all. When we've looked at this issue, it's clear that there needs to be more clarity given to employers about what will constitute an affinity relationship. During the public hearing and the work on the bill in the legislature, the law in the legislature, we were told, well, we're going to adopt a similar standard that California has, and that would be that an individual could designate one person as an affinity relationship per year. And that is what it appears that the department has done through these rules. But it has given no guidance to an employer on, what an employer is supposed to do or say when an employee comes to them and says, I'm going out on paid family medical leave to take care of a friend who is my affinity relationship. And what happens if they haven't designated that person in a timely fashion? Because the department really doesn't say, when do you have to designate this person, and how, et cetera, et cetera. The other issue is coverage is allowed for what's known as de facto relationships in the law. And there is no rulemaking language around what would constitute a de facto relationship. And in the law, it talks about de facto grandparents, de facto step parents, de facto parents, de facto siblings, etc. And an employer, particularly a smaller employer, if you're a small employer on this webinar today, I'm probably certain you don't have an HR department, but you're going to be expected to wade through and decide whether you're going to have a problem with an employee taking a 12 weeks of paid leave for a de facto individual when there's no definition of what a de facto individual is. So that also needs to be made clear in addition to the definition of affinity.
It's also interesting because as we go through the rules, there are specific aspects that discuss what the department itself is going to ask for as it relates to substantiating the need for leave. So anyone who has worked through an FMLA process in the past knows that we normally use a form. We have that form provided to a healthcare provider. It's returned, and if there is a need for leave for a serious health condition of a family member, a different form is provided. Here, however, when we look through the rules, there's no requirement for any form of documentation for an affinity members relationship. There's discussion about the department's ability to obtain documentation concerning a family member's serious medical condition or serious health condition, but there's no language applicable to affinity relationships. It's unclear whether or not that was purposeful or an error, but one of the things potentially to consider as we move forward, or when we ask the department to consider changes to the proposed regulations, would be to more broadly include affinity relationships in each aspect in which we ask for documentation concerning family relationships more generally.
And closely allied to the issue of affinity, because and de facto, because it does involve people going out on leave, is the notice or the lack thereof of notice to the employer in the rules. Section 6 in section H, it details that employers get a notice that the employee has filed for an application of benefits. And then there is additional notices that are provided to the applicant regarding either the approval or denial of that leave by the administrator. But there is then no back and forth between the administrator and the employer about whether this person has been approved and why, or disproved or why. So there needs to be a greater notice between a greater notice language between the administrator and the employer. Otherwise, the first time an employer knows that someone's out on leave is when they don't show up for work. So that's something else that folks should consider when drafting comments on this.
Let's jump to the next slide and get into one of the topics that we've also heard a lot about, which is the undue hardship language. And for this one, we want to start out with what the statute or the law itself provides, understanding that that kind of serves as the outline or foundation of what the rules then needed to accomplish. So under the statute itself, in section 850B, notice to employer. Absent an emergency, illness, or other sudden necessity for taking leave, an employee shall give reasonable notice to the employee's supervisor of the intent to use leave under the subchapter. So for the paid family leave program itself. Use of such leave must be scheduled to prevent undue hardship on the employer as reasonably determined by the employer. If an employer fails to provide notice as required under section 850I, the employee's obligation to provide notice is waived. So a couple things here, right? If you as a company fail to notice employees of their rights, so fail to put the posting up, otherwise provide written notice to employees of their rights under the statute after they're employed, this section doesn't apply to you at all. Second, there was significant confusion early after the statute itself was passed that the undue hardship language indicated that for employers with 15 or fewer employees had less obligations than all other employers. That's incorrect. All employers under the statute have the same obligation. This undue hardship language applies to all employers. Let's jump to the next slide, though, to understand what we mean when we say undue hardship as it relates to what the proposed rules are saying. So even though under the statute itself, it says the leave must be scheduled to prevent undue hardship on the employer as reasonably determined by the employer, right? So the employer determines whether or not there's an undue hardship. The rules itself shift that determination to the department. So an employer under the rules, and that's under section 5C. So where I say VC, that V is Roman numeral 5C, okay? It's not determined by the employer, it's determined by the department. And what they've said is that that undue hardship is a significant impact on the operation of the business or significant expenses considering the financial resources of the employer, the size of the workforce, and the nature of the industry. So it focuses in on the employer and these elements, and there's multiple elements that are missing that Peter's going to discuss kind of more generally, but there's also a very strict time frame. So once an employer receives notice of an employee's request for leave or to take advantage of leave under this program, the employer has 10 days to file a written notice that this could prove to be an undue hardship more generally. And they submit that to the department for the department's consideration of, do you meet the standards that are set forth here in the proposed rules to even be considered as an undue hardship? And if the answer is yes, then we're going to ask you to have a dialogue or discussion with the employee to try to figure it out. If you and the employee cannot figure it out, then guess what? The department's going to come in and they're going to schedule the leave to whatever they believe is reasonable. Now, Peter, I might have hinted to it a little bit, some of the issues that possibly come along with this undue hardship language, but what do you think? Oh, you're on, you're on mute.
My bad. So let's go back to the previous slide for a moment if we can, because it's important. Whoop, going the wrong way. There. The highlighted section, use of such leave must be scheduled to prevent undue hardship on the employer as reasonably determined by the employer. I think that's a very important phrase because while a lot was discussed around, well, you'll have an undue hardship that will help small businesses. If someone's a critical employee, the employer can reasonably determine that it's an undue hardship, and the employee and the employer would have to work something out rather than just have the employee leave. Let's go to the next slide where we just were there. But instead, what these rules do is turn the burden of proving that there's an undue hardship on its head, and it's now the employer's duty to prove that the burden of proof is on the employer that this employee's absence would be an undue hardship. I think under the current rules, if you're a large employer, it will be virtually impossible for you to meet this standard. If you're a small business, I think you will have equal problems. As Tawny talked about, there are several different notice provisions inside the rules that govern undue hardship. But here's the thing, if an employer fails to file a notice of potential undue hardship within 10 days, you have lost your ability to declare that undue hardship provision. And you might not know how critical this person was, or what happens if on day 10, you think you've got everything under control and a second employee files to leave and now you're going to be down 2 employees in an 8-person shop. So we have real concerns with the 10-day rule, the 10-day, one and done kind of provision. And nowhere in the rules does it address the critical employee component. This person is a critical employee and they're going to go out, and at this time, I can't afford to have this person go. If these things aren't brought up in the rulemaking, then I think the undue hardship provision, as we were always concerned about, will remain essentially ineffective for businesses. It's really critical that people talk about the fact that it's supposed to be reasonably determined by the employer, rather than making, essentially, it's the employer has to make the case that this is their problem.
The other, tough part about this is for any of my human resources generalists, anyone who's in the HR department who's on the call right now, we know that when a person goes out on FMLA leave, it's usually an evolutionary process, right? Especially if it's for a health condition, that health condition is going to evolve. That it could be that they need intermittent leave to begin with, and then it changes to a higher frequency of intermittent leave, or that we do a reduced schedule and then that changes and someone needs to be out for a longer period, right? There's no format kind of in the proposed rules at this point in time that would allow an employer to object if there is that evolution in the time needed. It's based off of that first application. If you do not object within the first 10 days, then you will have waived your ability to object to the reasonableness of this more generally. So specifically for intermittent leave issues, this becomes very difficult, in addition to what Peter's described as change in circumstances within the organization, change in circumstances of other individuals within the department itself. So keep that in mind as it relates to comments that you may consider providing to the department concerning these rules and how it's potentially going to affect your workforce. Now, you see that while on a lot of these slides, we have kind of a what you can do or things you can consider, right? In this situation, it's going to be very workforce dependent. How large are you? How small are you? How large are your departments? Kind of all of those different elements. So keep that in mind as you're considering what you believe it's important to bring forward during kind of the rulemaking process and the comment period.
Yeah, I just want to add one more thing. And I know a couple of folks have that I've been working with have talked about this, but under the rules that are currently that we're talking about today, a planned absence is going to be virtually impossible for an employer to declare an undue hardship. Again, if a planned absence, you've got 30 days notice, that et cetera, the likelihood that you would be able to successfully build a case with these current rules for an undue hardship is probably zero, because they don't take into account an employer's changing circumstances, other employees being absent at the same time, critical nature of somebody's job. None of those things are discussed in the rules.
That actually is a wonderful segue into our next slide. So let's talk a little bit about the employment protections that are listed within the proposed rules. And you'll recall that there's provisions within the statute itself that indicates that you cannot retaliate against individuals as a result of them taking leave pursuant to this program. Under section 4A2, employees are allowed to submit an application for benefits up to 90 days after leave has begun. So it can be either 30 days in advance notice, right? Or if there's exigent circumstances or an emergency, right? It can be less than 30 days, but as soon as feasible. Now that's as soon as feasible could be as late as 90 days after the leave has begun. And in certain cases, the department can extend the 90 days for good cause shown. Now, many of you likely have employees who one day simply stopped coming to work. Not just one no call, no show, but multiple no call, no shows, to the point that you believe there was job abandonment. Let's say that you perceive job abandonment because you have not heard from the employee for 5-10 days. So you post for the new job to hire someone to refill it. Peter, any concerns there as it relates to the current rules?
Yes. I think all of you have probably experienced what Tawny just outlined, that someone is, at first it's no call, no show, and then eventually it's just no show and that person disappears. That could feasible, it is feasible that an employee could be out on paid family medical leave for 90 days and you not know it. The 30 days could go by and you had not heard from this person. And you, as an employer under these rules, would then just say, I don't know where this person is. And again, this is a fact pattern and it's unusual. It's somebody who has to go out of state without any family and it's an emergency and you don't have a chance to notify anybody. You just, you declare, you're told your rights under the act to get your paid family medical leave and you don't communicate with your employer and the administrator doesn't communicate because right now, those back and forth notice provisions, as we've already discussed, aren't there. So the employee goes out and you don't hear from that individual for 30 days. You decide they've quit and I'm going to replace them permanently. The employee then shows back up, having filed 90 days after the leave has begun and said, you violated my rights because I have job protection. I was employed by you for more than 120 days, which is the standard for the protection of an employee's job under the law. We don't think that's fair. And so it's unusual to say the least, but we think there should be no job protections for an individual who has been absent for work for 30 days or longer, for which the employer has no notice from any source explaining the absence, and the employer has refilled the position. We think those are reasonable timeframes. It's not fair to the employer to be a mind reader and expect to know why this person has been gone for 4 or 5 weeks without any kind of notice. You refill the position, and now all of a sudden you find yourself in litigation for violating the employee's rights.
Let's move to some of the things that Peter just talked about, which is notice, right? So under the proposed rule, under section 6H, which is on, for those of you kind of who may be following along with the rule, it's on page 8. It provides that employers with notice that the employee has filed an application for benefits, and section 7 details various notices that are provided to the applicant regarding the decision of the administrator. So while notice is provided that an application for benefits has been provided, that's the only time in which notice is then provided to the employer. Peter, what are some of the issues that we're going to experience if all we get is notice that an application's been made?
Well, I think we just touched on them. The employer isn't going to have any idea. And there's a question in the chat where somebody says, doesn't the employee have to file for leave of absence to the ER? No, you don't. You file your intent to take the leave with the administrator, and there's not necessarily any notice back and forth between the admin and the employer that this person, they may get a notice that they have filed, but there is no requirement that then the department or the administrator follow up with a notice that says, oh, and by the way, they're out on leave. And furthermore, in an emergency situation like we just discussed, someone could deal directly with the administrator, not show up for work at the same time and still become eligible, having noticed the admin that they're out on leave, and they probably, it's an emergency situation, so they have documentation to back it up. But the employer might then not be noticed.
Now, if the need for leave is foreseeable, right? The proposed rules do provide that if it's a foreseeable need for leave, that the employee is required to provide the reason for the leave and not the specifics, but like family, medical, safe leave, qualifying exigency, the type of leave needed, whether or not it's continuous, reduced schedule, or intermittent, the timing and duration of the proposed leave, and then other details which the employee believes could be relevant. Now, none of this has to be provided in writing, and you cannot require employees to provide it in writing. So let's say that an employee says to their direct supervisor, hey, I'm going to need leave because I'm getting surgery next week and it's going to be a reduced schedule, right? Or whatever it is. That notice itself is sufficient under the rules that the whole employer has just gotten notice. You can't require them to complete a document. You can ask them to, you can say, here's the form, but you can't deny the leave in some format if the employee submits their application to the state and it's granted, and you just simply don't know any of these things are occurring if the person gave verbal notice to a supervisor if there was more than 30 days kind of before.
I think that's one of the most important points employers need to make in this, is that what you just said is absolutely true from a notification standpoint. An employee does not need to provide notice in writing to the employer of their intent to toll their rights under the law. Everything the employer does with the employee, however, must be in writing. And you'd probably want to do that anyway to protect yourselves. But we think it's critical that the rule be changed, that if the employee is going to ask for leave, that it be in writing. Otherwise, you're opening, I think the employer community is opening itself up to significant litigation, because people are going to argue when an employer files undue hardship or replaces that person, they're going to say, well, I told you, but there's no written record of it anywhere.
And when I use the term administrator, I mean the department. So the State Department of Family Leave, so they would just have to notify the department. Now, that's if you're using the state plan. If you were going to do a self-funded plan or you were going to buy a private plan, it would be letting whoever your plan administrator is know about the need for leave. But it wouldn't just be going to human resources. It would be following the plan document as to who gets notice and how long kind of in between the notice itself occurs and when the responsive deadlines are. Now, one of the questions that we did get about kind of notice is in the cases of job abandonment, what if employment was terminated, but the job wasn't needed or backfilled? and the employer can show proof of significant repeated attempts to contact the employee with no reciprocation or communication by the employee. Under the provisions of the law, there's no requirement if it was an exigency, if it was unforeseen, there's no requirement that the employee communicate with the employer. The employee's duty is to make the application to the department or the administrator of the paid family medical leave program. So the rules do not provide any kind of dialogue about if the employer makes X, Y, and Z number of attempts, if the employee fails to respond after this much time, that there is some type of exception, or that you are still required, that you permissibly can get rid of the position. So really good questions. Let's, so that, I know that it's hard to believe, but those are the most pressing concerns that we have. And in the next 20 minutes, we'll focus on other concerns, but we have a couple other questions, but we'll move to that slide about other concerns. One of the questions, does this take the place of the current state FMLA and all the stipulations that apply? No. For those of you who have 15 or more employees, you get to deal with this statute, and you get to deal with the unpaid statute and all the obligations that you have under that statute. For those of you with 50 or more employees, you get to balance the rules under the paid leave program, state FMLA, and federal FMLA. So no, we're going to need to work to marry all of these rules and regulations together as we are attempting to institute them.
Yeah, and to that end, in looking at the rules, Tawny and I aren't convinced that there isn't stacking allowed in these rules between the paid leave that's provided in the law, in this law, and the unpaid state and perhaps federal. It's not clear, and the ruling is, and the language is ambiguous, I think. Tawny?
So there's some interesting language specifically as it relates to how this interrelates to federal FMLA as it relates to ours. So there's language in the statute that says that unless the employer and the employee agree, that you have to take it in full work days, right, of 8 hours. Now, those of you who are obligated to comply with Maine FMLA or federal FMLA know that the smallest increment you can use is whatever the smallest increment is that you pay by, 6 minutes, 15 minutes, 1 hour, right? So arguably, you could have a situation where an individual, and you can't require them to take more than that. So if you had a situation where an employee had doctor's appointments and needed to be out of work for 1 hour, that would qualify likely as federal FMLA, but they wouldn't be entitled to paid Maine FMLA unless the employer and the employee agreed. But there is language in the proposed rules that say that if someone takes 1 hour of FMLA leave, federal, that time would be counted against the 12 weeks that they're permitted under the paid family medical leave program, even though they don't get paid for it, which is interesting as to how that works and is going to create, I think, significant confusion, especially for employees as they are notifying the department of their time away from work. And that becomes the other interesting thing. The employer, the company, does not communicate with the department about the leave or the time in which the employee was not working. The employee themselves communicates with the department once every 14 days. So the employer is not involved at all in those communications and not getting notice of those communications. So even with all these things that we've just talked about, let's talk about some of the other concerns that Peter and I and other practitioners kind of in this area really are concerned about. Next slide. So employer size, this is really interesting. And I see in the Q&A that we have some questions about seasonality. And that's why I wanted to skip over to this, even though I know we have some pending questions. In the proposed rule in section 10F, employer size for the purposes of determining what your premium liability is, which remember is different if you have 15 or more employees, right? Is determined based off of the number of covered employees as of October 1 of each year. Peter, what's one of the problems there?
Well, I've had conversations with people who are in the retail and the hospitality industry. And starting the 1st of October is going to be a very important time, because even though retailers for the holidays tend to start hiring in September, they're likely to hold off that hiring process until after the 1st of October. For the folks that are hospitality oriented, it's also going to mean taking a good hard look at whether you want to keep people on for the longer season, through October, the fall season through October. Because if you do, and it pushes you above the 15 employee threshold, you're going to be on the hook for paying the 0.5% payroll tax. So I think you will see a change in how businesses both lay employees off and hire additional employees due to this October 1 date.
Now, we got a really interesting question about what if you are a seasonal employer and you have an employee who seeks to take leave at the end of the season. Really great question. And this is one of the situations where, depending on your business, there are different concerns for different employers. And this is one of the big ones, is there's nothing in the rules that kind of set forth that. Similarly, I think a lot of the rules were created with a focus on, unfortunately, I think office jobs. There's language in there that in the rules itself, as it relates to a scheduled work week. Now, for any of the people who are on the call who work and have employees in retail and hospitality, scheduled work week we know is fluctuating. But under this rules, or the proposed rules, for individuals who are salaried, so our salaried employees, they've defined the work week as 40 hours, Monday through Friday, 8 hours per day. That's a traditional office job, right, in a lot of respects, but for a salaried employee who then takes Saturday off or Sunday off and doesn't come in, that's outside of the scheduled work week, and it's unclear then how that is going to play a role. Now, think about how it interrelates more generally with wage and hour law and the use of the salary threshold, kind of more specifically, do you lose salary exempt status if you don't pay an employee for one of the days that they were supposed to be working, because your belief was that they took paid FMLA leave, but it doesn't qualify as paid FMLA leave because it wasn't within the scheduled work week as defined by the rules.
Tawny,
Yeah, Peter.
to that question, if the seasonal employee takes leave right at the end of the 120 days, so if they have not been employed and then they return to the job and its business is closed, has closed the position because it's no longer needed. If they take leave and before the 120 days are up, there is no obligation for you to hold the job for that person. So someone could actually take leave under the law if they've worked for you for 3 days and still take 12 weeks of leave. But you would not need to hold that job for that person, nor pay any additional benefits for any longer than the 12-week period. So if the person came back and their job was gone and they hadn't been there for 120 days, I don't think there would be, under the law, there wouldn't be any requirement on your part. However, if they were there 121 days and they then took leave, then I guess I would argue that you would have a requirement to find them a comparable job in the business. The next question on unemployment insurance, Tawny, I don't know if you saw that one or not.
Yep.
So that's just been an ongoing issue that no one seems to be willing to address, and it's not addressed in the rules. And it goes back to the issue we just talked about, whether someone's worked for an employer for 120 days or not. I made the argument during the legislative session that if someone hasn't worked for you for 120 days and therefore hasn't earned the right under the law to have job protection, and you elect to, as the employer, you elect to replace that person permanently, and that person takes their 12 weeks of leave, and you're paying all their benefits as you're required, and you're paying all the benefits for the new employee, but you permanently replace that person, and when that 12 weeks of leave is up, are they then entitled to apply for unemployment insurance? And if they are entitled to apply for unemployment insurance, does it hurt your experience rating? And no one has been able to answer that question, and no one has been willing to. So that's my way of telling you, if you're going to comment on this, I suggest you ask that question and you ask to have it clarified.
One of the other pending questions is the lack of communication. How will we code leave when an employee is out? If it's paid time off, if it's earned paid leave, remember, we're simultaneously, we have Maine earned paid leave statute that's also applicable here, right? They're very good questions. Right now, the rules still don't provide, because they don't have the communication with the employer. That's part of it. The employee does the communication with the administrator or the department. So it could be that they're applying for the benefits with with the department, but they're also using PTO kind of more generally with the employer. And recall that you cannot require that PTO be used simultaneously with this program to supplement kind of pay more generally if you have individuals in a position where they're not going to receive the full amount of pay that they normally would, but would receive a smaller subsection based off of the calculation as to how benefits are determined. A lot of the other questions that are currently pending right now are actually based off of the law itself, not the proposed rules. So I would highly recommend that you take a look on our website as to what the law itself provides. And we have a whole, Peter and I did a presentation a couple of months ago on the law itself. Let's jump to the next slide though and talk about ability to work. So under the statute itself in section 850B, definition 3, medical leave eligibility, a covered individual with a serious health condition that makes the covered individual unable to work is eligible for medical leave. Now, unable to work is really interesting. What does that mean? Unable to do all aspects of the job? What about if it was light duty or restricted? Unable to work the hours that they're currently scheduled? Could you try to change the hours for the employee? There's currently no kind of reasonable accommodation dialogue that's built in here. Instead, as soon as a healthcare provider says cannot work, the program kicks in. Peter?
I mean, I think you hit the nail on the head. There's what I think employers should be asking for is a way to operationally or operationalize the issue around unable to work. Because I think employers might be able to say, well, rather than this person being out on paid family medical leave, what if I offered this person an alternative work environment, whether it was working from home, if they had a light duty work or restricted work schedules, et cetera, rather than losing the employee completely. But there's nothing in the rules to address the issue of unable to work, which is in the law.
Additionally, there's language in the proposed rule itself concerning having multiple simultaneous employers. There's no requirement that the employee take leave from all of their employers. So if you have someone who works multiple jobs, you could have them on leave with your organization under paid FMLA, but still working with another organization. So for any of you who currently have policies that provide, if we find out you're working while you're on FMLA leave or otherwise receiving an accommodation from us, you'll be terminated. That language in your handbook is going to have to change, because the rules itself, as they're proposed right now, would permit multiple simultaneous employers and an employee to work for those other employers, even though they're not providing services to you and your organization.
And in a very strange twist, again, going back to additional jobs or additional sources of income, the rule states that if you have an employee who is currently receiving workers' compensation in the form of Section 213 benefits for a partial incapacity or an injury that results in a partial incapacity, their benefits cannot be adjusted when calculating in the 213 benefits. And there is no method for an employer to go to the workers' comp board and ask for their comp benefits to be adjusted as a result of receiving the additional paid family medical leave benefits. It's kind of a surprise to see that in there. I want to point that out to people in case that's a concern.
Let's go to the next slide and talk a little bit about wage and benefits. So under the proposed rules, there is a broader definition of wages, kind of attempts to provide some clarity there. There's also some concerning language that if an employer fails to deduct the required employee share, which you'll recall is half of 1%, so 0.5%. If they fail to deduct that, or if their payroll provider fails to deduct it, right, then the employer is considered to have elected to pay that portion of the employee share, and they can never get it back. So if there was an administrative oversight in which you have failed to take the deduction, you've lost that deduction for whatever period of time the deduction wasn't taken, and you're going to have to pay that. Also, employers shall include in the pay statements information that indicates that paid family medical leave deduction has been taken more generally. Peter, thoughts kind of here more, more generally as to these elements?
I think this is a large business, small business issue more than anything else. The rules place substantial obligations on all employers to calculate the wages, collect all the information around wages, tips, gratuities, commissions, bonuses, for instance, the confusing one is stock options. If your employees get some kind of stock options, it appears that that needs to be calculated into the benefits, but that's a moving target and it isn't always available at the same time in a year when someone's going out on leave. So there's a lot of information, and a larger employer with an HR staff is going to be able to adjust to these requirements much easier than the sub 15 employee business that is going to be swept into this law and that have never had to do anything like this before. So what other business groups that I've discussed with have said is this really ought to be the requirement of the state to come up with this information. They collect this information. It's in revenue services. Why is it the problem of the business to come up and collect all this information when it should be at the fingertips of the state? And there's also should be a safe harbor provision in the rules for an employer that makes a mistake through made a good faith effort to comply but makes a mistake, and there isn't.
So we got an additional question, which was regarding the number of employees as of October 1st. So if there's fewer than 15 employees as of October 1st, then that organization is not required to pay the employer portion. They would still have to submit the employee portion. So instead of paying 1% of payroll, they would pay 0.5% of payroll, and it would come directly out of the employee's wages.
Or to be clear, some employers may wish to pay the whole, the entire amount. So if it's 1%, they could pay the 1%. Or if you're a sub 15 employee business, you could pay the 0.5% for your employees. But if you choose not to, as Tawny indicated, you will not have to pay the 0.5%, but you will need to collect the 0.5% from your employees and remit it to the state, whether they want to pay or not, by the way.
It's not a choice. Let's jump to our last slide. And we talked about this briefly, but it's about the work week. So the proposed rule does provide partial weeks or partial days of leaves will be prorated against the employee's scheduled work week. But that's problematic based off of the work week as it's defined kind of in the statute, specifically as it relates to your salaried employees, right? Additionally, with the smallest increment being 8 hours, unless the employer and the employee agree, this is even more concerning as it relates to our part-time employees, our per diem employees, people who work 10 out, like people in the medical field who may have 10 or 12-hour shifts, or in production lines who have longer than 8-hour shifts. So all problematic kind of generally, and things that need to be kept at top of mind as you're considering whether or not your organization wants to make verbal comment kind of on Monday to the department, or if you want to submit written comment. Peter, anything additional? I think we have a couple questions.
I think as we're getting on to the 2 o'clock hour, and I know people are going to start to drop off, I would just like to put for your consideration this. There are approximately 21 pages of rules. They're available online for you. And as a matter of fact, I will drop it into the chat right now, where you can look at the rules. If you follow this, if you follow that link, you will be able to find the rules and read them for yourselves. These rules will go forward as they are, unless there is comment and concern expressed by those who will be most impacted by it. And that is every business in the state of Maine. And rules get changed because the departments hear the same thing from employers. It's a volume issue. And I strongly urge that if you have concerns based on what you have today, you can certainly reach out to myself or to Tawny, but that you craft a letter expressing your concerns and get that to the department before July 8th, when the public comment period closes, or consider going to the public hearing on Monday. Once these rules have been done, it will be a while before we're able to go back and make changes to them, unless there is emergency rulemaking that's put forth. So I strongly urge you all to consider participating in this process, because it's the only way these rules will be altered.
Thank you all for your time. We want to be mindful that we are already over. We wish you all the best and have a great rest of your day.